You don't have time to waste. 15 days, I have discussed with my earlier students also. They said the last 14 days were very crucial for us. We completed everything there. We want to talk to them with respect to how to address your exam pressure and other things. And last moment strategy what they had. I can connect you with them on one. I can arrange one conference call like this, a meeting. You can talk to them if you are interested. Screen is visible to you. Is my screen visible to all?
Yes, sir, it is visible.
Okay, fine. So, right, priority of claim. We will discuss section 11. Section 11, first section is first subsection says that there should be every claim has a priority date of its own. Okay, we always say. In general, what happens is why the priority date is important. The priority date is important because novelty of a claim is dependent on its date of priority. We generally the date of priority is required with respect to evaluation of novelty or inventory step with respect to what documents you will be checking. Mainly, uh, now it comes to nothing published on or after the date of priority of a claim can be cited to destroy the novelty of that invention. So once there is a priority date from this date and below this, nothing can be cited. Always before that can be cited to destroy the novelty of an invention. Each claim of complete specification shall have a priority date that we have discussed. Now, generally, date of filing of patent application is considered as a date of priority. However, there are situations where that might not be true. Then comes, see, how, please understand, date of filing and date of priority. These are two different things. So the date of filing can be different from the priority date. And priority date, when I'm talking about priority date with respect to claims. Now comes CS filed with the patent application. If you file a complete specification along with patent application, date of filing will be considered as a priority date of that claim. See all that what is written here, I have just summarized it here. Now comes when you have then we have understood that after PS we can file a CS. Then date of filing of PS is the priority date of that claim. Okay. Then comes CS filed after PS1 and PS2, where PS1 and PS2 are cognate. Cognate we understood in the last time when we discussing if there are two or three provisional specification in which the invention which we have mentioned can be combined into one invention or a single inventive concept, then we have to know check. Then there can be multiple priority situation. So each there can be claims. For example, there are 10 claims. Two claims can have a different priority, and two claims might have a different priority. So the focus is simple. Claim based on PS1, we will go for data filing of that PS1. Claim based on PS2, we will go for data filing of PS2. Partly on PS1 and PS2, we will go for data filing of PS2. That is later filed PS will be taken so that the priority date, we will not take the earlier one, we will take the later one if there is a partly based on PS1 and PS2. Just remember this is a deviation from other other places where it is very clear that data filing of PS1, PS2 or PS is going to be taken. Then comes complete specification 2 has been filed after the conversion of CS1 into PS. Then date of disclosure in relevant dispatch. Since in this situation, what is happening is you have two types of claims. You already have a claim in complete specification, which was changed into PS. And then another complete specification was filed. So those claims which are repeating, it will depend on what date it was disclosed in a relevant specification. On basis of that, the priority date will be determined for the claim. Now comes post dating. If any application has been post dated, such post dated data filing will be considered the priority for that particular claim. Then comes CS. If company specification is based on a previously filed application in India, 12 months. Okay. Then date of previously filed application, if disclosed first, that will be taken. Then if suppose there is a divisional application, we have already discussed that the date of filing of such a specification of first mentioned application will be taken as the date. If it is a convention application, very clear, date of filing of the basic application filed in the convention country will be considered as a priority date. So this is the entire concept of priority date. We'll go through it and try to remember this. In general, simple rule is if there is a PS, date of filing of PS will be the priority date for that particular claim. If there is a conflict, there is a partly PS1, partly PS2, we will go for PS2 because then only the claim has completely been described. That should once it is completely described, then only I will go for a priority. I cannot go for a half disclosure of invention. So that way, claim which is talking about claim which is deriving its is deriving for PS1, PS2 both. I will go for PS2 date of filing there. Now, divisional application, we all know that first mentioned application we have decided. That's why there is a data filing of that. Otherwise, on convention application also, if there is a base application on basis of which the convention application has been filed, we will go by the data filing of that. So entire thing is data filing in general is the same, except in few places where there are one or two application. That is PS, either there is a provisional specification file or there is a base application. Now, we have already known, before this publication of application, now we will go for publication application. In general, I would just like to see, first thing we understood is what? That there is a, you have forms, right? You follow the forms. Okay. Yes. So when you are filing the applications. You are filing the applications, right? In application, tell me the form. Tell me which form you are using for what? For
Form 1 is
what?
for application of the patent, sir. Form
Correct.
2, complete specification and provisional specification.
Correct.
Form 3, statement and undertaking. Form
Check.
5, declaration to inventorship. Form
Correct.
26 is authorization of a patent agent.
Correct. You all cannot sit silent. It has been done, no? If you will forget this, how will it happen? Section 39 application you are going for, which form will be used?
25.
25, right? Or 22?
25 only, sir.
25 set, 22 for patent agent registration.
So, it's what? Form 20, what?
It is for small educational institution, startups, small entity.
Data, then the ability that small entity, educational institution and startup. 28 is fine because fee is getting reduced. So you have to submit this as a document as an evidence. कि ये होगा. Okay. From application. Now, the date you file, it is a date of filing, right? So from date of filing, there there is 18 months. In 18 months, what can you do? If you don't request for publication, after expiry of 18 months, the application will be published. Before, when I'm talking about 18 months, within 18 months, within 15 months, you have the right to withdraw the application. Correct? Okay, you can withdraw the application. And before that, within 12 months, you have a right. If you have filed the PS, you can file CSE. Okay. So these are 3 timelines. Please see. 12 months, 15 months, 18 months. Now, one more thing you would be remembering that post dating cannot be beyond 6 months at a time, right? So see, if PS is getting post dated, it will shift to 6 plus 12, total 18. So data publication, so their timeline are matching, they are not against each other. Fine. So hope you all understood this. So once it is, what is necessary for publication is you have to file the request for publication. That is not necessary. You can sit quietly and it will get published. But if you file, you want an early publication, you can go for request for publication and it will be published. Once it is published in the official journal of patent office. This is how.
And how much time period? Sorry, sir. Within how much time period they will publish it, sir? Like normal publication, early publication.
Within 1 month they can publish, and after publication till 6 months. They will wait 6 months. They cannot grant the patent before that.
Okay, sir. Thank you.
So when it is, sorry. See, I will discuss it again. Don't worry. What I'm saying is, once it is published, there are 18 months. If you don't request, it will be published. It will be published in the official journal of the patent office. In the official journal of patent office, every Friday, it is weekly basis, it is being published. Please note that you can get an MCQ on that. The journal is published on weekly basis on every Friday, covering the various proceedings of patent as per the provisions of section 145. Okay. Sorry?
Before 18 months also, can we have a publication, sir?
Yes, you can have it. I have told that there can be a request for early publication. You will pay the fee for file the form 9 and it will publish. I'm coming to the sections. I'm just giving you a rough flow chart. Don't worry. I am coming to the sections. I'm just giving you a brief overview how it is working. So in this journal is being published. So this, please remember, the section 145. Under this, an official journal is being published on. Official journal is published on every Friday. Okay. Now, this has these many things. There are early publications. Then they are talking about publication after 18 months. Then they also tell about where FER has been issued, weekly what FER has been issued with respect to each office. They also talk about that. They also talk about the restoration of the lapsed patent. They also tell you, okay, now the grant. These 4 are grants. What publication with respect to grant? These patents have been granted. Then comes, this journal is also important for the design publication under Design Act. So this is done there. Okay. And this copyright publication is with respect to Design Act, not Copyright Act. And then goes this. See, their territorial jurisdiction on journal basis, these are the, all that is written. We have discussed the jurisdiction, so I'm not going there. Then it talks about this. Any person at any time before grant of patent may give representation by opposition to this. They are also giving that you can oppose it under 25(1) once it is published here. And any interested person can request the copy of complete specification drawing an abstract of any application already published. 8 rupees per page. Okay. So I will share this general with you. Please go through the highlighted portion. So if they are also saying if by mistake, if there is a duplication of publication, the earlier date of publication will be taken for the purpose of provisional protection of the application. Patent office will grant patent not before 6 months from the date of second publication. Okay. Now comes, see, this is how your published patent reflects. Now, let's go through this. There will be a patent application, application number, territory, date of filing of India, publication date, title. Okay. Then there is a name of applicants here. Right. On inventors are here. International classification, international application filing date, publication number, international publication number. This is not applicable. It will not. It's not a divisional. It's not a patent of addition to this. So nothing is there. Then you can see there is abstract. People of all ages must be affected by dangerous. This till this. Okay. So then how many pages are there? Pages number is there. How many claims are there? That is also provided in the publication. But claim is not provided. So only title, abstract, and this is being provided. If you request, then a public application which is published, that will be given to you. You can search the public application using these numbers on the patent public search website. You can go through the new recent official journal and read this abstract and title. Okay. Just for understanding of how the applications are being titled or numbered. That will help you. See, every time it is a question, where should I read the title? You can read the title as well as the abstract here. But the problem here, this abstract is if there are that has not been drafted by a patent agent, you will not get the good abstract. Therefore, a public search with respect to your interest is recommended so that you understand the correct form of abstract, and mainly you go there in public search and go for granted patent, because then abstract is approved by the controller and that will be conforming to all the requirements which is necessary. Now, so please go through this official journal. 2 or 3 pages you have to see. Just look into this because the look and feel helps you in remembering better than cramming it. So if you go through this, there can be a question: what informations are published in the patent application when it is published? What information is published? This is the information which is being published. If you see it, you will start remembering it. You can do that. Okay, now let's go to the sections, what the section is talking about. Please remember, 11 is talking about the priority. 11 is a very auspicious number, so it is talking about priority. It is priority based number. Then 11A talks about the publication. Then that is also very important. So see 11A, you can remember like that also. Okay, 11 is very auspicious. The moment 11 comes, priority comes. Then 11A gives you publication. Then says, I will go to the direct now. Please see, I have cut it because this is no more relevant because section 5 has been deleted. It is omitted. So this is no more relevant. It is just there, lying there. Similarly, this after 25, I don't think it will be more necessary because all this will also break out. After year 25, 20 years will be completed and there will be no patent holder for with respect to 2005. After 25, this will also lose its relevance. Now, Please remember rule related to publication 24 and 24A. They are relevant and this rule you should not forget. Now, publication of patent application. See, an application for patent is not open to public before the expiry of 18 months from the date of filing or date of priority, whichever is earlier. Then goes at the end of the period, as mentioned in para A above, the application is published in the official journal except in the cases when it will not be published. If there is a secrecy direction under section 35 or if the application is abandoned. When the application is abandoned, you all will remember in section 9 we said that if there is a provisional specification and within 12 months complete specification is not filed, the application will be deemed as abandoned. So that application is called abandoned. Then comes third part. Application is withdrawn. Withdrawn means that within 15, before the end of 15 months, if data or from the date of filing or priority, whichever is earlier, if you are withdrawing your application, then it will not be published. Then comes the patent office. Patent office publishes the in official e-general. Ordinarily within 1 month, the first query which you have asked from the date of expiry of the period from 18 months and within 1 month it will be published. Then comes where secrecy direction has been given, then the application will be published after the expiry of the period as till then from the date secrecy direction is ceased. This expiry of period is 6 months. Application will be published after the expiry of the period in which in para. Okay. There. Right? So what it will be there if there is a secrecy direction 18 months. If 18 months has passed and secrecy direction continues, then when the secrecy direction has ceased to operate, that the later date will be taken. If it is before, then within 18 months, otherwise after the expiry of the secrecy direction. Then comes publication of application under section 225 or level shall be identified by letter A. With this we have already discussed that application had started with A, then 2004, then 4 or 1, whatever 4 is the this number of the patent office which is going where it has been assigned, and then the number 1, 2, 3, 4, 5, 6, 7, 8, 9 it denotes which kind of application is there, and then the application number is there. Then comes early publication. This is you can request for an early publication. Form 9 will be used. Such as request will be considered only if the complete specification has been filed. If you have not filed a complete specification, it will not be published. Further, a patent application shall not be considered for early application if an invention pertains to the subject matter relevant for defense purpose, because it has to go for perusal that whether a secrecy direction will be issued or not. Then, if you have requested, in general, a public application is published within the 1 month from the date of such request. Then comes particulars of publication. Same thing, I have just shown you. Patent Office Journal is published on every Friday. Following things are found there: application number, country, date of filing, publication date, title of invention, international patent classification, priority details like priority document number, priority date, priority country, international application number, filing date, name and address of applicant, name of the inventor, name of the inventors, reference in respect to patent of addition, reference in respect to divisional application, abstract, number of pages, number of claims. Okay. So all this is there. Okay. Once you have published a patent application, what is the effect? Effect is once you publish it, the specification, whatever the specification, abstract, drawing, any document file in respect to application available to public on its website, and copies of the same can also be made available on the payment of prescribed fee as given in the first video. So you have said that we have seen that on request of 8 rupees per page, they are ready to provide the photocopy. After publication of the application for the patent, the depository institution. Please remember, the depository institution is with respect to biological materials, and you have deposited under the which treaty?
Budapest Treaty.
Correct. Only you have read or others have forgotten. Please answer. The depository institution. So Budapest Treaty, in Budapest Treaty, biological record has to be deposited. There are depositories. How many depositories are in India? I have. So anyways, three, right? Earlier there were two. One is new, Maunad Bhanjan. Then comes the deposit. These depository institutions shall make the biological material mentioned in the specification available to public. So after publication, they will be public. On and from the date of publication of the application per patent until the date of grant. Now, from the date of publication till the grant, it will be like that applicant has the privilege and right as if the patent of invention has been granted. That means you can start working. You will have all the protection with respect to your right. With respect to licensing and other thing, you can consent and they can work on it. However, no patent shall be granted before the expiry of 6 months from the date of publication of the application. Why is this? What is the logic behind this? Any guesses? Why 6 months is? Why you have to wait for 6 months after publication?
Say for pre-grant opposition.
Yes, to give the public or public a chance to oppose the application. Now, after publication, what comes to the first thing comes to the picture? If it relates to defense or not, that scrutiny has to be done, and because of that, secrecy, direction, and consequences will be there. So there will be provisions of secrecy of certain invention. It starts from 35, then goes to 35. Talks about that. If there is a defense purpose, how the controller will inform the central government, and central government, if he takes, they can issue a secrecy direction. Then 36 talks about that secrecy directions are once given should be periodically reviewed. And the review can be on the basis on the period, that is time passed, as well as on the request of the applicant. Then comes what is the consequences of secrecy direction that section 37 talks about. After that, in 37, and then we go to 38. 38 talks about can secrecy direction be revoked, or there can be an extension of time with respect to, because extend the time for doing anything required or authorized to be done under this act in connection with that application. That can there be an extension of time by controller with respect to that? This is talking about section 38. 39 we have already learned. This is a foreign filing license. Then comes 40. 40 says that any contravention of 35 and 39 will result in what? So 40 is talking about that if anyone contravenes 35 or 39, the application of patent under this act shall be deemed to have been abandoned. Please remember, this is also an abandoning clause. We will deem it as abandoned, and the patent granted, if it has been granted, it will be revoked. It can be revoked under the section 64. These two liability are there. Okay. And 41 says that whatever secrecy direction central government says, all those orders as well as the controller's orders with respect to secrecy are final and cannot be taken to the court. You cannot challenge them in the court. That is the finality. Then comes that all the disclosures, okay, saving this is a disclosure to government. So nothing is the disclosure by the controller advice concerning an application, this, the government for purpose of application, this exam or especially be given for considering whether an order in the share should be made or whether in this the care controller, there is nothing. Controller has always a right to disclose the government, nothing can stop. Now comes secrecy direction. A flow chart I have made just for easy reference of entire this 42 sections. So an invention pertaining subject matter, after once you have submitted, they looked into it before publication. They have to check whether subject matter is relevant for purpose of defense. If yes, then controller will issue a direction prohibiting the publication of the application and notify the applicant that this is being considered for secrecy direction. Refer the matter to the central government for consideration as to whether the publication of application would be prejudicial to the defense of India. So if it is directly, then he can issue the direction prohibiting the publication, or it can refer to the central government and wait for their direction if there is a confusion. Central government, after considering the merits of the secrecy direction, is of opinion that publication of invention would not be so prejudicial. They will ask to remove the secrecy direction. अभी आप आए यहाँ. So they will ask controller to revoke the direction and notify the applicant accordingly. Okay. Suppose secrecy direction has been issued. They found that this is for defense purpose. What will happen? Then the continuation of secrecy direction will be reviewed. Every 6 months, it can be reviewed if you are not requesting. If you are requesting, applicant can consider that it should be reconsidered. And if controller finds that the request is reasonable, he will forward this. He will request the central government to review that if secrecy action can be lifted. Then comes reconsideration or review. Government can reconsider and review and can ask that public and understand if that time has passed. Now the publication is done. No longer be prejudicial to the defense of India, or whether it can be published outside India if there is a foreign equivalent. If the government is fine that this is not prejudicial to the defense of India, then yes, it can ask the controller to revoke the direction of secrecy. Controller will revoke the direction given previously to him, and the result of every reconsideration, whether acceptance or rejection of that, will be communicated to the applicant within 15 days from the receipt of the notice by the controller. Now, this is one way is that controller is requesting. Central government gets to know that there is an invention which is relevant for defense purposes. It may at time before the grant of patent notify the controller to that effect. Secrecy direction will be issued and central government will be notified. Now, in order for grant, what is happening is during section 35 secrecy direction, what will happen? The consequences. Controller will not take any decision on the grant or refusal of the application. However, application is subject to the direction proceed up to the stage of the grant. That means it can be examined. But the application is found to be in order for grant of the patent shall not be published, and no patent shall be granted in pursuance to the application. So publication as well as grant will not happen, but it can proceed up to the stage of in order for grant. Where an application is found to be in order for grant of a patent during the continuance in force of the direction, then use of invention. If there is government has been using it under the, then we will consider that the provision of section 100, 101 and 103 will be applied. We will discuss those. This is 100 to 101 to 103 is related to the government use case. So it will be, if government is using, it will be considered as the patent has been granted to the invention. If government thinks that because of my secrecy direction, the person is facing problem. What is the main problem which he's facing is he's not getting the money. He's not getting the license fee or anything. So that hardship, they can make a payment by way of solatium, which will be reasonable with respect to novelty and utility of the invention, purpose for which it is designed, and any other relevant circumstances. Whatever government deemed fit will give you. Please remember, it is a solatium. That since you are suffering a hardship, I am paying you some money. Then comes patent granted. Where a patent is granted pursuant to an application in respect of which direction have been given under section 35. Since till the section 35 was in force, your patent was under secrecy direction, then you are not supposed to pay any renewal fee for that particular period because you could never exploit it properly. Then no appeal shall lie from any order passed in respect thereof, as we have discussed earlier in the section 41, I think. Yeah, finality of the orders. So this is how your publication and secrecy direction would work. Now come for the withdrawal of the application. Withdrawal application is very clear. You can withdraw before grant anytime. But there are different time period and their effect. If you withdraw before 15 months, before expiry of 15 months, your application will not be published and will not become a prior art. The benefit is that you can modify and come back and go for the invention again, because it is not barred by your own application as a prior art. Now, second part is, suppose it is published, but before first examination report is issued to you, you have gone for the withdrawal of application. So you can get 90% of the fee of request for examination and expedited examination refunded. Please remember, only the request for examination and expedited examination will be refunded, not the fee of application which you have filed. Then comes which form has to be used. Form 29. Form 29 has to be, you remember 28? This is 29. And what is Form 30?
Miscellaneous forms.
Miscellaneous means where no form has been prescribed, you will use the Form 30. So you are done with 1, 3, 5. What is Form 4?
Extension, request for
Extension of
extension.
time. Now you understood that 1, 3, 4, 5 you know. Now you also remember 9, publication. 9, Form 9 for publication. You remember, you go back, you go down, you remember 26, 28, 29, 30. Right? No problem there. Now, and 25 also. You also remember 25, 25, 26, 28, 29. Okay. So, which form is left? After 9, you have to go for examination. Double the 9. 18. Form 18 is for examination and 18A is for expedited examination. So request for examination, the very good part of this is that publication can happen without your request, but examination will not happen without your request. There has to be a request for examination. Otherwise, if there is no request, it will be deemed as abandoned. It will be treated as withdrawn. Please remember. In case the applicant or any other interested party does not make a request for examination, it will be treated as withdrawn. So no request, no examination. And the examination section is 11B. If I go back and remember all the sections, 3 is what is not invention, 4 is atomic energy exception, that which is not patentable. Then 5 is missing, 6 is an applicant, 7 is application, 8 is section 8 statement and undertaking, 9 provisional and complete specification, 10 the requirements of complete specification, 11 priority date, 11A publication, 11B examination, right? Section 35 secrecy direction, section 39 fund filing license, section 40 liability in contravention of 35 and 39. 40, 0 is an offense. Oh, you remember that. 40, 0 talks about the offense which is related to 39, 40. So 35 and 39, if you relate that, you will remember the section like this. Okay, now since there is no request, no examination will be there. Who can request it? Request can be made by applicant or any other person interested. And who is an interested person? T121T defines who is the interested person. Any person engaged in the same field promoting research in the field or in same field that of invention is an interested person. So please remember this definition. This interested person is very important definition. It will again come when we will discuss the post grant opposition. Okay. So first thing, no request, no examination. Publication plus request is necessary for examination. Request. Now there is one question. Suppose you didn't go for request of publication. You filed an application, and at the time of filing of application, you also requested for examination. Can you tell me when your examination will be taken?
After 48 months, sir.
After 48 months. Please listen my question very carefully. You file an application. Okay. On the date of filing of the application, you filed a complete specification, of course, and you immediately requested for examination. When will your application be examined?
After requesting for publication.
You don't need to request for the publication, no.
Automatically after 18 months also it will be get published.
Yes. So what is the answer? Right answer. What is the right answer? शैलेंद्र सिंह जी बताइए.
So 24 months.
24 months. How you calculated that?
So 18 months plus 6 months.
Who is saying 18 months and 6 months? Saptarshi.
Yes, sir.
Okay. Why 18 plus 6 months?
So 18 months for the publication and 6 months for the pre-grant opposition.
I'm saying 6 months. Okay. Anyone else? Dr. Ramuthan, please tell. Any attempt? Sudhakarji, can you attempt? Say, no one is attempting, then I'm telling. Okay, see, very clear. Don't get mistaken by any of the juggleries or question is being asked. First thing is very clear. You have filed for examination. You have not filed for the early publication. So your application will be published only after 18 months. Before publication of that, of your application, it cannot be examined. Right? It has to be published. Then only it can be. You can make a. Then only it can be examined. So first it has to publish. So once it is published, then there can be an examination. Since you have already done it, immediately after publication, we will go for examination. We are saying 18 months. After 18 months, within 1 month, it will be published. So after publication, we have 6 months for not examining, for that within 6 months, it will not be granted. But examination can be done, no? So the examination will be after the publication. It will be ASAP. It will go for examination. Examination, it will be referred. Now come. See. Request. Now period in which request can be made is from the date of filing plus 48 months. If you don't request date of filing or date of priority within 48 months, you have to request. If you don't request, I will deem it as withdrawn. And the then if how which form will be used for request for examination? ROE. Here I am referred it as ROE in form 18. And request for expedited examination will be in form 18A.
Sir, one
Now,
clarification I need.
yes, please. Yes.
Sir, I heard that 48 months is reduced to 36 months. Is that the true or fake?
No, it is neither true, neither fake. The thing is, a draft patent rule has been circulated in which it has been proposed that the time limit should be reduced to 36. Since it is a draft rule, it has not been accepted and notified as a rule. The draft rules do not have any binding. So first, 36 has been recommended, that is true, but whether the 48 months have been reduced to it, no, it's not, because rules have not been notified. They have not come into effect. Till the rule itself is notified, there will be no effect.
Okay, sir. Thank
So
you.
rules have not been amended till date.
Thank you, sir.
Okay. Okay. Now comes request for expedited examination. Yes, this is very important point which you have raised. There will be various sections which are circulating in the market with respect to draft rule. That is the public expressing their opinion on the draft rule, whatever is happening, or they are giving you a concise summary of the draft rules. Okay, people will be posting some blogs and other things. Don't get confused with them because they are not yet part of the Patent Act and rule. When they get part, they will become your syllabus. Before that, no, they are not the syllabus. Syllabus is Patent Act and rule. Since they are not part, they are not. Yes, as a general knowledge, if they are going for a general knowledge question, can they ask? They should not ask, because if they are asking, nothing is to stop them. But they should not ask because it's not part of it and it's still under the consultation and discussion. Consultation papers and consultation drafts bills are not part of your syllabus. Now comes request of expedited examination form 18A. Then comes special cases. What are the special cases? Suppose you have filed a request for examination of an invention under secrecy direction. What will happen? Within 6 months from date of revocation of the secrecy direction or 48 months from priority date filing date, whichever is later, it will be examined. Request of examination for divisional application. Same, within the 6 months from date of filing of further application or 48 months from date of filing of first mentioned application, whichever is later. Then comes international application designated India. The request for examination, normally we understand that after 31 months, we enter into the national phase. We have 31 months before, till we can wait before entering the national phase. However, if you want your application to be examined early, you can always request for examination in international application also. Even before the expiry of 31 months, they will examine it. Now comes how the examination of an application happens. So examination of application happens is when you request an examination. So it is referred to at the earlier, the controller will receive your request and he will ask an examiner to make a report. Examiner prepares the report and gives it back to the controller. Okay. Now what is examined is that all the requirements of acts are being followed. So the we will check application specification, other document related to our in accordance with the requirement of the act. For example, assignment, all those documents for if you have claimed Form 28 is submitted or not, if you are a small entity, startup, or Form 26 is there or not, or within a particular period that Form 26 has been submitted or not, declaration of inventorship has been submitted or not, or the assignment part, if there is an assignment agreement, is that been given to you or not? All those things are checked, and on basis of whatever is missing, they will inform you. Then whether there is a lawful ground of objection to the grant of patent. When I am talking lawful ground of objection, all those things they will check. Okay. Novelty, inventory step and other things, as well as the claim drafts or other things that will be done. Then says the result of investigation made under the section 13. Section 13 is nothing but the novelty check, which talks about anticipation and other things, the investigation which is done there. That result will be made there. Then any other matter which is prescribed, they will go for. Prescribed means provided in the rules. So all those things, if it has been prescribed, yes, this is examined. Then we go for section 2. It talks about that to whom the examiner will make the report to control. Now I'm just giving you, this is a comparison between examination and expedited examination. Steps are same, only timelines are different, and you have to remember those different timelines. If there is a question on examination on expedited examination, follow that. Please remember the rules for publication, rule for publication of examination and expedited examination. Everywhere, please remember these three rules. The rule number is important for these sections or these rules. First, examination is done under Rule 24B, while expedited examination is done under 24C. Form 18 is used for examination, request for examination, while request for expedited examination is under 18A. Who can file for request for examination? As we have already stated, applicant or person interested can go for this. However, expedited examination is available only to these people, not to all. That is, if India is indicated as International Search Agency or elected as International Preliminary Examination Authority under the PCT route. If then you can go ask for expedited examination. If you are a startup, if you are a small entity, okay, or all applicants natural, and if all are individuals, and there is one female applicant. Please remember this. This is very specific. All individuals with one female applicant, then you can go for 18A. If all are individuals but all are males, you cannot go for this. If all applicants are not there, the applicants are individual as well as a company or entity, any other entity, you will not get the expedited examination facility, even though there is a female applicant. Okay, go for government department. Any government department can ask for the expedited examination. Statutory institution which are owned or controlled, that is PSUs, if they are owned and controlled by the government, they can go for it. Any statutory institution whichever has been published and has filed for this. Statutory institutions are those institutions which have been incorporated under any act or state government or central government. All are statutory institutions. Statutory institution is institute established under any act. That is called statutory institute. Government companies are companies which are run by government. Now comes government finance institution wholly or substantially. If wholly or substantially financed, government has been financing that institution, they can also go for expedited examination. Sector which has been noted by central government, if those sectors, the companies are in those sectors, they can also go for expedited examination. And arrangement between Indian Patent Office. If that IPO has an arrangement with a foreign patent office, if they are extending us an expedited examination, and or we are extending them the facility of expedited examination, it can be done. Okay. Now, what are the requests? You can request for request of examination in hard copy as well as online or offline, both way, but expedited examination can only happen with electronic part only. Now, conversion. There is no need for conversion of ROE. This exists simple. ROEE cannot be converted into ROE, right? But ROE can be converted into ROE. That means normal request for examination can be converted into request for expedited examination. What will happen is a prescribed fee you have to face. As far as I remember, 4,000 is for this one, request for examination. If you go for ROE, it is 8,000. If you are going converting it, difference has to be paid. Now go for refer to examiner. See, controller refers to examiner 1 month from the date of application, whichever is earlier, or request for examination. Within 1 month, it will be referred to the examination from the date of application or request for examination. In order of filing of ROE, it will also be 1 month here also. This is the place where time gap reduces. Examiner has to give the report within 1 to 3 months, but he can delay also, not a problem there. But here 1 to 2 months is strict. He has to submit his report, examination report to controller in 1 to 2 months. Then comes disposal of controller. Controller will dispose the ER after the receipt within 1 month. There is no timeline change there. After that, controller will send the FSO or first statement of objection or first examination report to the applicant within 1 month by from the date of disposal. While in that 15 days. Then application in order. What are the timeline? What is application in order for grant? When I am talking application in order for grant, that means that you have to comply with all the requirements, you have to satisfy all the objection which has been raised in your examination report. If you can satisfy all that, that means you are putting your application in order for grant. There you can challenge and get the objection removed, or you can comply with the objection, whatever suggestion has been made, and get your application approved. Okay. So you get 6 months from the date of issue of FER in general. And you can extend this only for 3 months. The total 9 months you can get maximum. But before the expiry of extension, before expiry of the 6 months, you have to file the extension, a request for extension under Form 4. However, let's go to the expedited examination. Expedited examination, it talks about 6 months from the date of issue of FER and plus 3 months extension on the request. Again, you can ask for that. This is again same. Right? Now, rest part. Time limit on disposal by controller, no limit. However, controller has to take a decision once you have given an objection, whether you have put the application in order or not within 6 months. Controller is not bound to give you an order immediately. However, in expedited examination, he is bound within 3 months from the date of last reply to FER or last date to put application in order, whichever is earlier. He has to say yes or no. Decision has to be made. This time limit is not applicable if your application goes for a pre-grant opposition. So this is the entire comparison between examination and expedited examination. So I will stop today here only. We have discussed that how the application is drafted, how the application is filed. After filing, within 18 months, it is to be published. If you don't request for the publication, it publishes. And if you request for the publication, early publication, within 1 month it is published. And after that, we can request for the examination. If we request for examination within 48 months, if we don't do that, it will be considered as withdrawn. If we request for the examination Then it goes for controller refers to examiner. Examiner examines it, include the section 30, and after all those law as well as the act regulations, whatever is there, they have to come. They have to comply with that. With respect to all the discrepancies, you received an FER. That examination report is given to controller. Controller looks into it and takes 1 month. It has a time of disposal for 1 month, and within one month it disposes the application, sends you an FER. Within another 1 month, you receive an FER. You have 6-month time period to comply, challenge, or whatever you want to do, and put your application in the order. If you cannot put in your application in order within 6 months, you can request for extension of time for 3 months. After that, there is no extension. It's done, and then controller has to take a decision. It takes a decision whether to accept or reject your application for grant of the patent. If he accepts, grant of patent will be given. Now, this is the general format. In expedited examination, timeline little changes, rest is same. Go through this. Tomorrow we will discuss the subject matter, which I have not discussed in the first time, section 3 and 4. What is not invention? Because when you are examining, first thing is we go for whether it is a patentable subject matter or not, whether it is an invention or not. Then we will go for the novelty and inventive step and other requirements. So first we will understand what is the problem of subject matter and other things. Then we will go for the novelty examination and inventive step examination. What are the exceptions there? And then we will go for the grant. This is what we will be discussing tomorrow.